Subsection 8. Allowance and disallowance of wills. Article 838. No will shall pass either real or personal property unless it is proved and allowed in accordance with the rules of court. The testator himself may, during his lifetime, petition the court having jurisdiction for the allowance of his will. In such case, the pertinent provisions of the rules of court for the allowance of wills after the testator's death shall govern. The Supreme Court shall formulate such additional rules of court as may be necessary for the allowance of wills on petition of the testator. Subject to the right of appeal, the allowance of the will, either during the lifetime of the testator or after his death, shall be conclusive as to its due execution. Article 839. The will shall be disallowed in any of the following cases: 1. If the formalities required by law have not been complied with. 2. If the testator was insane, or otherwise mentally incapable of making a will, at the time of its execution. 3. If it was executed through force or under duress, or the influence of fear, or threats. 4. If it was procured by undue and improper pressure and influence, on the part of the beneficiary or of some other person. 5. If the signature of the testator was procured by fraud. 6. If the testator acted by mistake or did not intend that the instrument he signed should be his will at the time of affixing his signature thereto.